SJC-13778, Armand Fontaine, individually and as personal representative of the estate of Barbara Ellen Fontaine versus Philip Morris USA, Inc.
Attorney Chesson.
Good morning, and may it please the court. Scott Chesson from Chicardi for the appellant. There's a lot going on in this case. If I had unlimited time, I would talk about everything, but I don't. So subject to the court's preferences, of course, it's my intention to talk about passion and prejudice, about the procedural safeguards, and about preemption. So starting with the elephant in the room, this case involved the same defendant, the same alleged conduct, the same evidence of wealth as in innumerable prior trials, both here in the Commonwealth and elsewhere. And this jury returned a punitive damages verdict that is 100 times higher than the next highest verdict against Philip Morris here in this Commonwealth. And as we explained in the brief, an order of magnitude higher than any punitive damages award in any kind of case ever in this state. And all in a proceeding where the jury was permitted to hear evidence of the defendant's substantial wealth at the same time that it was making foundational decisions about liability, compensatory damages, and eligibility for punishment in the first place.
But I get that.
Yeah.
The difficulty, I think, for you is that that $1 billion award is no longer at issue. So what we've got is the compensatory damages award and the remitted amount of the punitive damages. And so how do you connect your contention that the size of the original punitive damages award indicates prejudice such that it affects the compensatory damages award, which doesn't seem to me, frankly, to be out of line, and you don't really argue that it is comparative to any other wrongful death claim, correct?
Correct.
Or with respect to the remitted amount, because the remitted amount is the product of judicial decision-making, not the product of the jury.
Correct. So the one part of, I will agree with Your Honor that 56 million is less of a problem from a blank.
But it's also, if it's a problem, it's just a different problem because it's the product not of the jury.
I agree. I want to be clear. The initial question for this court is whether you should presume that the entire decision-making process was tainted by passion and prejudice because of what this jury actually did. That's a separate question from, if you disagree with me on that, what the constitutional maximum might be. That's a separate question. But it's our contention that a jury faced with the same allegations, the same defendant, the same wealth, that does something that is such an outlier, not a moderate outlier, but that is so outrageously larger than anything that's ever happened before, that makes the process suspect. In particular, and to address Your Honor's question directly about what does that say about the compensatory award, that's the point we're making with respect to bifurcation. Had this trial been phased the way the defendant asked for it to be phased, then I would be making a very different argument right now. Maybe something went off the rails in the second phase and that caused—
I don't understand how your argument logically holds together, with all due respect.
Absolutely, I'd like to—
Because let's assume you establish that there was some kind of prejudice, passion, call it what you will, with respect to the original punitive damages award. You're not making an argument, at least I don't think, that same sentiment affected the compensatory damages award.
Oh, I am.
Okay, so then, but what have you put in to show that that amount is out of line with other wrongful death verdicts?
I want to be clear. I'm not saying that if this were a different verdict, if this jury had returned $8 million in compensatory damages and some modest multiple of $8 million in punitive damages, I don't think the court would be in a position to presume that that decision-making process was tainted by passion. What I'm saying is this jury wrote one check. This is a jury that, before returning a verdict, sent a note out to the judge and said, if we award punitive damages, who gets to keep it? And the answer that the judge sent back correctly was the plaintiff does. So the jury came back with a $1 billion, $8 million verdict in favor of the plaintiff.
So you're asking that we vacate the compensatory damages award because the punitive damages award, which has now been remitted, was too high?
Yes. And I don't think I'm out of line with the case law to do that. What the case law says is, the case law says, and I grant, I mean, the case law says this is an extraordinarily rare remedy. This almost never happens because these sorts of verdicts almost never happen. But when the award of damages is so grossly disproportionate to what the evidence will bear.
The award of compensatory damages was not disproportionate to what the evidence could bear.
I agree with that. And all I'm saying is I think the jurisprudentially, sort of logically based, like the thought process that the court is supposed to go through is, what do we think of this decision-making process? If the answer to this question.
Yeah, I understand your point. You're saying that the fact of the $1 billion punitive award suggests that the entire process from beginning to end was just not based on the evidence, but based on passions, because Philip Morris happens to be a very wealthy company.
And maybe I'm sorry.
So to go on beyond that, I think that's the argument. Beyond that, though, the judge here, Superior Court judge, looked at multiple factors and said, well, actually, this was quite an attentive jury. They asked a lot of questions. They differentiated on the compensatory side between family members. They didn't award everything. They were discerning. So I reject Philip Morris's argument that this jury, just because of the $1 billion award, suggests that they were just operating on passion. And I didn't see a response to that part of the analysis.
Well, I'm happy to get, I think we did it in the reply, but we're limited on words.
You should have done it up front, but go ahead.
Well, I have a couple of answers to it. The first is what I've been saying to Justice Wolohojian, which is, once we're in the realm where something extraordinary happens with that jury, the fact that it was otherwise attentive, the fact that it asked a bunch of questions, the fact that it was well educated, doesn't eliminate the presumption that something has gone wrong.
So once you have an award that's of this type, automatically it's a reversal? Is that what you're saying?
Well, I'm saying the case law says there's a presumption.
Right. And so what happened here was that the Superior Court judge quite rightly said, understood, let's take a look at what actually happened. What actually happened doesn't look like it supports that presumption anymore.
Right. And all I'm saying is, a jury that wasn't influenced by this, at the very least, this evidence of massive wealth, may have come to a dramatically different conclusion on everything.
Excuse me, are you contending that the jury was not allowed to consider evidence regarding, say, the company's annual profits when deciding the amount of punitive damages?
So I'm not contending that on appeal.
Correct. So you admit that at some stage of the proceedings, bifurcated or not, they could hear that Philip Morris, I think the evidence was $6 billion a year, correct?
The evidence was it was a $3 billion net worth and something like $20 million a day in profits, multiplied out. There's no question that there was evidence of substantial wealth. But I mean, I take what I'm getting.
But don't we, when we think about a $1 billion verdict sounds so huge, but it has to be understood in the context of the case.
Right.
And Justice Wentland highlighted a number of factors that the judge mentioned in saying that she thought that the jury had done a deliberative job here. And an additional factor, in addition to their behavior questions, finding for Philip Morris on one of the alternative
which didn't
designs,
affect liability.
Another was the evidence that existed, correct?
There was evidence of, look, Your Honor brought up, it's just in the premise of your question, this trial could have been bifurcated, and these concerns, there would be.
But I don't want to talk about we've already conceded that the compensatories don't seem out of line with the evidence. So the question is about the punitives and whether they, notwithstanding that the compensatories don't appear out of line, indicate that bias and prejudice entered the proceedings. And so my question for you that I was trying to get at, albeit slowly, was, this is a case where the judge exercised her discretion and found, having observed the trial firsthand, that this jury appeared attentive. There also was evidence that made $1 billion judgment have some relation to the annual profits of the company. And so my question for you is, what is your rule that you're proposing for us to adopt about how we look at a really high judgment when there's evidence that a defendant has a really high net worth such that a large amount of money might be necessary to deter them? I want to hear what your rule is.
So here's the rule. The first is, and I know I'm itching to go on this, there should be procedural safeguards. There should be a higher standard of proof. There should be bifurcation, which eliminates the guesswork. But if we're within the realm that Your Honor is asking me questions about, I do think it's out of line with the evidence. The evidence was this company has a $3 billion net worth, and the evidence was there are a number of other cases pending against this defendant, and the notion that
That's not evidence in front of the jury.
Oh, absolutely it was. The net worth evidence was before the jury. The fact of other lawsuits was before the jury.
And the outcomes of those?
No, not in part because the case wasn't bifurcated, so that's not the sort of thing that a defendant is going to put in a unitary trial. But the fact that there are other potentials, the jury was instructed, consistent with Philip Morris versus Williams, only punish for the harm to this defendant. Don't punish for the entire course of conduct. The jury heard evidence that lots of other people sue Philip Morris every day. The jury heard evidence that 50 state attorneys general had sued Philip Morris, and as a result, there's billions of dollars in ongoing liability. So this is just to address the narrow question of whether it's consistent with the evidence. I think a jury that thinks in this one individual case, stripping the defendant of a third of its net worth, I think that is extraordinarily suspect.
So why isn't remittitor the correct mechanism to address that?
It is if, as I'm receiving from the court, if Your Honor is disagreeing with me that the size of this verdict coupled with what the evidence will bear indicates that something else is going on in the decision-making process. If you're disagreeing with me on that, then yes, the proper remedy for the excessive verdict is remittitor. I mean, we have an issue with how much the remittitor was.
Sure, and that's reviewed, I think, for abuse of discretion, correct?
The amount of the remittitor is like what the constitutional maximum is. That's a de novo review.
No, not the constitutional maximum, but how the judge
there's passion and
exercise.
Yes, I am not running from the standard there, but I have to point out. So, like the case law says over and over again, reversing a trial judge who has found there's no passion and prejudice is extraordinarily rare, or whatever the formulation is. I've read every case we cited, I've read every case they cited, I've read most of the cases I think that those cases cite. I don't think anyone has brought you another case in this posture where a judge said, this verdict is so extraordinarily excessive that I need to reduce it by 95%, like with the consent of the plaintiff who stands to recover, 95%, and didn't find that there was passion and prejudice. No one has identified a case. Usually, when this court is deferring to a trial judge's ruling on passion and prejudice, it's when the trial judge leaves it in place.
There's no necessary conflict between finding that this jury was not animated by passion or prejudice, and yet the verdict is excessive. That's not a necessary conflict.
So I would respectfully disagree with Your Honor in this sense. So the ruling from the trial judge was that the verdict was unconstitutional to an extraordinary degree, to cut 19/20ths out of it. If you read the Supreme Court cases on what it means for a punitive damages judgment to be unconstitutionally excessive, the Supreme Court says that means it's arbitrary. That means the defendant did not have fair notice of the quantum of punishment to which it was subject if it misbehaved.
But isn't it, it's a substantive due process, that single digit test. That seems to be what the judge did here, right? She realizes she's got the constitutional overlay, and the single digit analysis by the U.S. Supreme Court requires this. Isn't that the best protection you've got? And it's going to be much more effective than clear and convincing evidence and
So
bifurcating trials. You know?
respectfully, no, I mean, it is a good protection, but
I'm not sure it's going to, the Supreme Court's going to keep it, but
well, that's a question for another day. But yes, I mean, the Supreme Court has said it violates substantive due process when an award is outrageously high. And just to finish my answer to Justice Wolahojian, what that means, according, you read all the Haslip and BMW and State Farm, what that means is it's arbitrary. Under Massachusetts law, when an award is arbitrary, the remedy is what we're asking for, not a remittitor, but a new trial. But one way or the other, I mean, Justice Kaffer, I agree with you that that is reducing it. I mean, we can quibble whether it should be 7-1 or 4-1 or 1-1, but reducing it is a way to cure that problem. But I don't think it takes the place of the ex ante protections that virtually every other state to have considered this has put in place.
but those are put in legislatively. And
not all of them. I mean, we cited this, and then the chamber did it better in their brief because they had additional words. You know, so on clear and convincing evidence, it's something like a dozen states have done it through court decision, and even on bifurcation, I want to say Texas, Florida, Wyoming have done it by in the absence of statute. But my point, to answer your question directly, does an after-the-fact remittitor serve the same function as an ex-ante procedural protection? The answer is no, because if you're disagreeing with me on its passion and prejudice, and we're all agreed, even the plaintiff is agreed, that it's unconstitutionally high, the judge's job at that case is to reduce to the constitutional maximum, whatever the court believes the constitutional maximum is. That doesn't cure the problem of a properly instructed jury or a jury who hadn't heard this evidence at the right time, whatever it is, might not have chosen to award at the maximum, may have chosen to do something else. Like, these are complementary procedural protections. No one, not the plaintiff, not any of the amici, no one has given this court any substantive argument for why either of these things is a bad idea, doesn't protect rights. I mean, on bifurcation, there's law in this Commonwealth. It's a discretionary call, but our argument is, even under existing law, the judge abused that discretion. What we argued to the judge before trial was Rule 42B, there's case law on this, says you're supposed to evaluate the potential prejudice, the potential for juror confusion, and interests of judicial economy. Nobody denied that there was serious potential for prejudice. Neither one of us were arguing that the jurors were going to be confused. Middlesex jurors are smart. But the only argument that came from plaintiff at the time, the only argument that comes from plaintiff now or any of the amici is bifurcating trials will make them longer. And respectfully, that's just not true. We're not talking about adding additional evidence. We're talking about segregating the evidence that is otherwise coming in, such that if the jury finds that punitive damages aren't warranted, the case is shorter. And if the jury finds that they are warranted, that evidence that has been held back now comes in a second phase. Maybe there's an extra opening and closing that increases the length of a 17-day trial by 90 minutes.
Can I ask you a question that is trying to reconcile your argument that the punitive damages should be reduced to the amount of the compensatory damages, and the fact that you haven't appealed the Chapter 93A determination. So
Just to be clear,
if it's
we think we have.
okay, well, all right, whether you have or not. So our legislature has clearly enacted a statute that permits that, and in fact requires multiple damages if certain showings are met.
Yes.
Those showings are actually less than the showing required for punitive damages.
Willful and wanted versus malicious.
So why on earth would we ever think that a punitive damages award should be reduced down to no more than 1 times the compensatory damage amount, where the jury could find, the facts permitted the jury to find the standard for punitive damages?
So to be clear on how wrongful death punitive damages line up, just in terms of numbers with 93A. 93A, once the judge or the jury, once the fact finder makes the finding, it's either double or triple damages, meaning 1-to-1 or 2-to-1. That's double damages.
2-to-1 or 3-to-1.
One additional damages, 1-to-1, or what I'm calling 1-to-1 is add an extra $8 million. That's what 93A would call double the damages. 16 million would be triple damages. You're adding it on to the compensatories. My argument on 93A would be precisely the same as my argument on constitutional due process, which is what the Supreme Court has said is the purpose of wrongful death punitive damages is the same thing as the purpose of 93A punitive damages, which is to punish and deter. What the Supreme Court has said is whether, when you do something bad and as a result money has to come out of your pocket, whether that money is intended to compensate or it's intended to punish or it's something else, it's going to have an effect on you. So the higher the compensatory damages, the lower the necessary quantum of punishment in order to achieve those goals. So if we're talking about an $8 million compensatory damages verdict in a 93A case, I'd be making precisely the same argument to the trial judge or whoever the finder of fact is if you find liability, you are required to double, but you should do no more because anything more is unnecessary because the amount of compensatory damages is so substantial, particularly for a defendant like this, where this is not the only case, where you have to think of it in terms of if you were to universalize these amounts across the universe of cases, what's the total punishment for the total course of conduct? It's a substantial amount, and so the necessary damages are lower. And that's our, and I'm not wedded to 1-to-1. I'm not blind. I know what the case law says. But my only point is the higher the compensatory damages, the lower punitive damages need to be in order to achieve that purpose. So I see my red light is on.
I do have a question, though, on one of the procedural things, the clear and
Please,
convincing standard.
Yeah.
Are any of the dozen or so states that have adopted that standard, are punitive damages available only by statute?
So it's 3 dozen states, not a dozen states.
No. I thought that there was only a dozen states that did it by judicial decision.
Right, that might be true, yes.
So as to those states that did it by judicial decision-making, were those states in which the punitive damages are only available by statute?
I don't know the answer. I'm happy to send a letter, but
No, I can look that up. If you knew, you'd save me the time.
I don't know the answer. Assuming, because I assume this is where you would be going if I had answered, no, they're all common law jurisdictions. Assuming that's the answer, I don't deny that this is a good thing for legislators to legislate on, and certainly if the general court here in the Commonwealth wants to pass a law, they can. But I think it is extraordinarily clear that in the absence of that kind of legislation, this is, I was listening to the first argument this morning, which is very interesting, about the line between, judicial functions and legislative functions. There's no question that things like this, procedures for how trials are conducted, standards of proof, setting burdens of proof, in the absence of direction from the legislature, that is this court's job. And that's existing law from this court on when the clear and convincing evidence standard applies. It's in a lot of contexts, including statutory contexts. I mean, the SORA decision, the Doe versus the Sex Offender Board, that's a very persnickety statutory scheme, but it doesn't specify a standard of proof for designation of sex offender status. And so this court steps in and says, we're going to examine that unless and until we're told something different from the legislature. And what I'm saying is the Massachusetts legislature, and I understand, they've got a lot on their plate, and there's only so many things they can do. But as I said, there are, I think we've identified only 2 states that have ever considered this question, either legislatively or judicially, and not adopted a clear and convincing evidence standard. I mean, there's robust case law in this Commonwealth about when such a standard should apply. And it's when there are important individual interests at stake, and the risk of error should be allocated in a certain way. And you have a case called McDonald, which is cited in all of the cases that we cite that I was reading the other day, that goes through this in some detail and says, look, in an ordinary civil context where the plaintiff has an interest in having his or her rights vindicated, and the defendant has an interest in not being, wrongfully held liable, the interests are balanced, so preponderance of the evidence makes sense. But once we shift, here in punitive damages world, we shift to the plaintiff has been fully compensated, no longer has either a constitutional or a sort of a statutory interest. Punitive damages are a windfall for the plaintiff. If the legislature wanted to take away punitive damages altogether, they could. There's no right to it. It's provided because the legislature thinks it's a good idea to incentivize people to bring these suits. But the interest for the defendant in avoiding the stigma of having their property confiscated by the state as punishment has a constitutional dimension to it. So if we're trying to figure out how we allocate the risk that the fact finder is going to make a mistake, it makes sense to allocate that risk to the plaintiff and not to the defendant. So I've been talking for 11 extra minutes. Thank you all.
Thank you. Okay, Attorney Humphreys.
Thank you. May it please the court, my name is Celine Humphreys, and I represent the plaintiff and the appellee here, and that's the Fontaine estate. Something just occurred to me in hearing that final wrap-up. I think part of the confusion that's caused in this case is the reference by Philip Morris to passion and prejudice, passion and prejudice. And in my brief, I explained that they don't follow the applicable legal standards for many of their questions that they're raising. Which, by the way, the result of that is many of these issues are not even cognizable because they're not taking the law that applies, the standard applies, and saying we meet that. But the thing I just came up with together that occurred to me, passion and prejudice, one, the standard of proof. They're saying that changing the standard of proof was necessary to avoid passion and prejudice. But that's not what this court's case law says when it discusses the burden of proof, any of them, or the United States Supreme Court case law. When you find it is appropriate to impose that medium or median standard of proof, you do that when an important interest is at stake. That's it. Just like the United States Supreme Court. That's termination of parental rights. That's involuntarily civilly committing somebody. That's when it's appropriate. None of the cases they cite make the point constitutionally we need to avoid passion and prejudice. And then the other point I made in my brief.
Well, I think to be fair, the point is not on that specific issue, passion and prejudice, but just as between plaintiff and defendant, where the defendant is being whacked to deter the defendant, the preponderance of the evidence standard shouldn't apply because the whole point of the standard of proof is sort of a proxy of if we get it wrong, what happens? And when on compensatory damages, it's sort of 50-50. If we get it wrong, maybe the plaintiff has to prove it just a little bit more. But here, the point of the punitive damages award is to deter the defendant's conduct.
So I think
that was the point.
Well, to be respectful, I think they made both points. So their primary point.
But can you address that one?
I'll address that one.
Yes, thank you.
It's a secondary point that this is kind of quasi-criminal. And we do respond to that at length in our brief, and so does the amicus brief submitted by the Massachusetts Trial Law Association and the American Association of Justice, which explains a great example is look at the uniform case law dealing with RICO violations, which deal with systemic criminal conduct. And even there, uniformly, the courts, based on United States Supreme Court precedent, use the preponderance of evidence standard. And there, Your Honor, not only do we have something akin to a punitive damage assessment, although it's more like 93A, it's a multiplier of damages, you also have even more extreme consequences. So the defendants in a RICO action, they might be required to disgorge the profits. They might be limited in activities they're allowed to engage in the future. Sometimes organizations are required to disband. Very significant outcomes. Preponderance of the evidence, preponderance of the evidence. The other point.
Sorry, could you
Yes, ma'am.
turn to the passion and prejudice argument?
Yes.
And what, in your view, is there a number that a jury would come back with that, okay, sorry, you go.
So that was my second, that's why it all kind of went aha for me, because also passion and prejudice is their argument for a new trial. But they're citing one piece of evidence, the amount, one piece. That's an excessive argument. That's what their argument is. It is really a remittitor argument, as you identified.
Well, don't you think that if the jury had come back with evidence, with a verdict that said $800 trillion, and they had written $800 trillion on the verdict form, they had done the same thing with the compensatories, exactly the same careful work through the verdict slip, but then they wrote $800 trillion. Wouldn't there be some question in that case whether this was motivated by passion and prejudice?
So like 5 answers just came up to my mind. I'm going to start with my primary point, which is really a failing of every argument made today, except, well, even the constitutional one. They ignored the standard. The standard, even under that scenario, the 1 billion, this trillion billion, multiple trillions, requires the trial court to look at, requires the movement alleging the prejudice to look at the entire record, the whole record, and then also establish that there's a miscarriage of justice. That's a standard they never even identified. And as your questions have pointed out, they didn't look at the record at all. We're the ones that had to discuss the record. So in that case, presumably in the context of punitive damages, one of the critical factors is this of what the amount is. One of these critical factors is the resources. So, for example, one of the things we cited to you is the fact sometimes juries return $100,000 in punitive damage, and we provided you one of those verdicts. $100,000, that's not even a traffic ticket to Philip Morris. So part of what, in that situation, applying the standard properly, multiple trillions of dollars, that does not sufficiently match up to what their resources were, at a minimum, even if we're going to look at that. But I also think one of the many answers that occurred to me to respond, and I hope I'm not pivoting here too much, is, again, the brief by MATA and AAJ really do a fulsome job of explaining what happens here when we're talking about punitive damages is actually kind of a different calculus. All of the authority that deals with remittitor, new trial in the event that the aggrieved party, whatever, rejects the remittitor. In punitive damages, we're not doing some sort of determination of facts and calculation of resulting damages. It is not a factual finding by a jury. The factual finding is, does the conduct warrant, do we think it warrants being punished? Then it becomes moral condemnation. And the check on moral condemnation is not, would the trial judge do the same with the evidence? That's where the constitutional doctrine comes in. That's where the constitutional doctrine says, we're going to have some outer limits here instead of doing a piece by piece. And that would happen in your example as well. And that's what happened here. Absolutely. We came forward and we acknowledged, and I heard a statement again today that was much like their brief. I want to be very clear. We think that the jury's verdict was supported by the evidence. This didn't even amount to 17 days of revenue for them. 17 days. That's shorter than the trial.
You sort of jumped into the remittitor pretty fast. You
Doing it,
well, you're not trying to defend the billion. You ran away from the billion as fast as you could, right?
because part of what's missing, and you'll see it in the record, and we do cite it, but we don't flesh it out because a lot fell on the floor because of page limitations. But there was extensive debate during the charge conference on jury instructions.
I'm just saying, let's focus on the remitter for a second.
I am.
You agree, we can't do the billion's not going to go, right?
Like you said,
but-
the 1-to-1 ratio. And
So it's all based on the constitutional.
it's all based on the Constitution. And in fact, if you look at just that part of the discussion, I was going to go back to the charge conference to explain why we brought it up during trial, but let's just go to that moment when the jury, returns the award. It was Mr. Chesson, it was my co-counsel, Mr. Rayner. They are discussing, and Mr. Rosenblum, who couldn't be here today, they are discussing the constitutional limitations. That's all anyone was talking about. We brought it up saying, Your Honor, we recognize constitutional law, 1-to-1 ratios are presumed, so we're fine with telling them no more than 9-to-1, staying in, even though we've now provided you many examples, including a Philip Morris case Williams, where it's 97-to-1. So it was all constitutional. So first of all, there was no statement by us ever in court or in paper that this was not supported by the evidence and the jury was doing something that it could not. This is simply a fact of what happens in trials. It's a risk we litigants undertake. But the other point I was going to take you to a moment ago was when you go to the charge conference, Philip Morris itself brings this issue up, often wanting the juries to be instructed on these constitutional principles. So that's why the idea occurred to us. It's an instruction they want, and they were even considering asking the judge to give it in this circumstance. So I do want to make sure that I talk about, and I heard this in the first argument today, when the court is using its powers to basically come up with new procedures of its own on how the superintendent power, how cases should be conducted in the future. To the extent that Philip Morris is making any of these arguments systemically of how things should happen, we responded to them, frankly, while a lot of them don't make sense. But if this court does decide to adopt any of these procedures, despite all of the reasons we provided in the brief why these procedures should not be adopted, we do want to ask the court that ruling be made prospectively. There's no debate, there's no argument by them that these are constitutionally required, and that's the only situation where it would be retroactively and applied to our case. So I did want to be sure to make that point. Another point I wanted to address was 93A. There's a few things I can say on that. So I guess I need to address what they say in their reply brief. We point out the fact that at a minimum, everything except for the punitive damages determination would be affirmed based on the 93A order that they did not appeal. They said, oh, yes, we did, as they've said here today. And they pointed to one place in the record, in their brief, and it's at the end of the statement of facts where they simply say that a 93A order was entered. Nowhere in their brief do they mention the 93A order. Nowhere do they discuss that it was infected too, that somehow the passion and prejudice that carried away the jury also impacted the judge, or that the judge sort of maybe bifurcated his thinking on or her thinking on this. No arguments. And all that they say in their reply brief are two things. One, they say, but we asked for a new trial. Yeah, they asked for a new jury trial. That was their argument. It's not the 93A ruling. Secondly, they gave a legal argument, which I'm happy to respond to if you want me to. But the bigger point is that legal argument should have been in the initial brief. The only other point I wanted to clarify, and it was just based on how the questions were posed for the amicus brief, I do want to make clear that there is no contention, and plaintiffs did not present any evidence that so-called neutralized the warning labels. The only evidence that plaintiff presented was evidence that Philip Morris had countless formerly confidential documents, and in those documents, Philip Morris self-acknowledged that these warning labels were not very effective, and that evidence came in without objection. So I wanted to make sure the court understood.
I'm just trying to, the Wiggett argument, which is, so how is that not getting into the duty to warn? I'm just trying to, I understand you don't bring a duty to warn claim, but you're pounding them for not keeping in the Wiget, right?
No.
Or am I misinterpreting?
Well, there's a lot to digest here, and there's so many issues, and the preparation for today was astounding, so I can only imagine all the reading. So there's a couple points about the Liggett warning labels. First of all, the context. The context is back in the 1990s when the federal statute required warning labels, it only addressed the harm potentially caused by using cigarettes. It did not address the fact that cigarettes are highly addictive, let alone, as addictive as something like heroin, right? So one cigarette company on its own decided to add additional warning labels, not just talking about the harm from addictively smoking, lung cancer, whatever, but also saying, and the nicotine in cigarettes is addictive. When Philip Morris bought those cigarette brands from its competitor, it took those labels off. Okay, so that's the context, the factual context. It came in for one reason, and only one reason. Philip Morris robustly made two defenses to our case, to the jury. First on causation, telling the jury, this woman knew, she knew what she was doing. She knew that cigarettes were dangerous. She knew that they could kill her, and she decided to smoke anyways. And therefore, their position was she was 100% responsible, not even comparatively, 100%. And one reason she knew is because we provided information. We provided information on the cigarette packs. We provided these things that are called onserts and tear tapes. We told her, so when she bought our cigarettes, she had this information. Philip Morris argued the same point to say, and we don't deserve punitive damages because regardless of our reprehensible conduct decades ago, we've reformed. And for example, we disclosed this information on our cigarette packs with these onserts, and we removed terms like lowered nicotine or lower tar and lower nicotine. And we're like, well, that's not the whole story. You took information off. They opened the door. So that's our easiest argument. And that's one of the many examples where Philip Morris does not acknowledge, they're required to identify the ruling expressly, doesn't identify it, doesn't address the evidence surrounding it, and clearly doesn't establish that it was capricious, it was whimsical, or any other things that would make it reversible. But more to your point, it also did not, and it was never off, not only was it not offered to establish a failure to warn claim, there was no failure to warn claim. I mean, that's the principal point, and the amicus brief on
it's a deceptive advertising, right? Do you have,
no,
it's a fraudulent something or other. I assume it's based.
Oh, there is a fraud claim, and then you have.
And it's based on deceptive advertising, right?
Yes, and you have robust case law, particularly from the United States Supreme Court, but previous decisions from you that the two are different.
No, I understand they're different, but I'm wondering whether they get merged when.
No, because that's part of what the preemption brief addresses, is when you look at what it addresses, again, part of the many pieces of paper that fell on the floor to get the brief short enough. When you look at what the act does, the Labeling Act, the sole purpose of the Labeling Act is to say, we are going to require these labels be on cigarette packs. And because we're stepping in as the federal government states, we don't want you imposing we're saying this is what's required. And then to the extent that a tort principle can be used to say you should have put more on there, that's not allowed. And that's what a failure to warn is.
It's the clause, and I don't have it right handy. The Supreme Court had something about, adds a sentence about misleading, and you can't use this.
Right.
That clause. Do you want to address that briefly?
Yes. And so what it says is the fact that the states, whether it be by legislature, by any kind of act like that, or by case law, can't require more warnings. Doesn't mean.
And there's this. Yeah, go ahead.
Doesn't mean that the party, the cigarette companies, that a civil action can't be brought on the fact that they themselves misrepresented information regarding the same information in the warning. So the fact that they committed fraud, that they misrepresented facts about health, that they did a host of things. They created false scientific research, all of these things that then interfered with the public's understanding about cigarettes. That is still able to be addressed in tort litigation. And I too have gone over my entire time, but I do want to answer any questions. There are so many issues in this case. Does the court have anything else for me?
We're all set.
I want to say it was an honor. Thank you for letting me appear today.